that. I don't need any more information. I told you what I'd rule right now. You're indicating to me that there are other calls that may lead this court to form a different context to what was said. And so, why does he keep talking to me? Court does call the case People versus Sean Caldwell.
Your Honor, Jonathan Evans on behalf of the people.
Welcome back, everyone. Today's courtroom battle is about to test one of the most controversial legal questions in criminal law. Can a defendant lose the right to challenge evidence if the court believes they intentionally caused a witness to disappear? What starts as a routine hearing quickly turns into a tense legal showdown involving recorded jail calls, a missing complainant, and arguments over whether fear, manipulation, or something entirely different kept a key witness out of court. The judge isn't rushing to conclusions. The defense is pushing back hard, and the prosecution believes the evidence tells a much darker story. Every word spoken today could determine whether this case moves forward or falls apart completely. Stay with us, because this hearing is packed with legal twists that only get more intense as the evidence unfolds.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Caldwell.
All right. All right. We ready to proceed on this matter? There is the motion.
You know, there is a motion that was filed by the previous attorney handling this case. Essentially, that's the victim's statements to the officers pursuant to forfeiture of wrongdoing. I think that they're also admissible under 768.7C. So, different ways of these statements to come in, but I'm prepared to argue the motion as it was.
Right away, this hearing shifts into a highly technical legal debate. The prosecution isn't arguing whether the alleged crime happened. They're arguing whether certain statements can legally be admitted into evidence despite the complainant not being present in court. That's a huge distinction. If the judge agrees that the defendant's own actions caused the witness's absence, the defense could lose one of its strongest objections. This isn't just procedural. It could completely reshape the trial before it even begins. What do you think? Should courts allow statements like these when a witness doesn't appear? Or should live testimony always be required?
What's this case before me? Oh, because he was in custody. That's why. All right.
If I may approach with Defendant's Exhibit 1, which is a printout that indicates that the complainant has a bench warrant. And with this...
Out of what court?
Out of the 14B District Court. And, Your Honor, it does... so our full argument in terms of the exhibit, we have other arguments as well, but in terms of the exhibit, is that Mr. Caldwell is not the cause of wrongdoing. In reviewing the documents with regard to the bench warrant, Ms. Caldwell was arraigned on or about September 28th of 2022.
I'm sorry, say it again, huh?
She was arraigned on or about September 28th of 2022. That she stood mute and that the court scheduled a pretrial for her, attend the next pretrial date, which was also in 2022. She attended a pretrial November 16th, 2022. And another hearing was scheduled for February. I want to say one more thing about that. In terms of this November 16th, 2022 date, it does appear that at the scheduled pretrial, that not only was another pretrial scheduled, but also, I believe, a show cause hearing was scheduled.
Now, the defense introduces something that could complicate the prosecution's theory, a bench warrant. Their argument is straightforward. If the complainant already had legal reasons to avoid appearing in court, then it's much harder to prove the defendant caused her absence. In legal terms, the prosecution must connect the defendant's conduct directly to the witness not showing up. Simply pointing to phone calls or a difficult relationship isn't enough by itself. This is where courtroom cases often become battles over cause and intent, not just emotion.
January this year, and Mrs. Caldwell failed to appear. she did appear, as I stated, at least 2 other times, both and would have been aware of this court date when she failed to appear, and likely is aware that there is a bench. I do have that as your.
Sorry, we're saying it's the last date. 23, right?
That's,
Okay.
and that being the date that the bench warrant was issued.
And so your indication is, or you're indicating to the court, at least, that the only reason she's not here is because of the.
I'm indicating that on the papers that Mr. In terms of the pleadings that have been submitted by the prosecutor, that they are not able to show by a preponderance of the evidence all 3 of the things that are required for 804B6, which is that Mr. First wrongdoing, that wrongdoing was intended, and I'm specifically talking there that the wrongdoing did procure the unavailability. My argument is that they cannot show that by a preponderance because there is, in fact, a warrant for her arrest. And
Here's an important legal point the judge is focusing on. The existence of phone calls alone doesn't automatically prove witness intimidation. The court wants to know what was actually said and whether those conversations reasonably suggest coercion, pressure, or an effort to prevent someone from appearing in court. Judges often look beyond isolated statements and evaluate the entire context. That careful approach is critical because one wrong ruling on admissibility could dramatically affect everything that happens at trial.
that is correct, Your Honor. However, just the fact that there are phone calls, and those are the portion of the phone calls.
Pardon?
And I can discuss the phone calls. But just the fact that there are phone calls, which are a bond violation, does not mean if there was that necessarily is the reason that she's not here. They do have to show by a preponderance that there was wrongdoing that was in some way coercive, threatening, or with regard to her appearance, and that wrongdoing in fact caused her not to be here by a preponderance of the evidence. And that is pursuant to People v. Burke.
I understand that. And I guess my question is, have we heard all of the phone calls?
I have heard the majority of the phone calls. I actually received probably well over 100 syncs in terms of calls. And I can say that, let me start with this bit, that the various links are from a multitude of different dates. There's one that and they are not in any order. There's one that refers to the 20th in terms of a conversation, and it's not.
Well, my issue is I'm not so much concerned about the date as what was said, and that's why I'm asking where they listened to.
And that is why I'm going to the next point, because I cannot tell what date each of the calls were made, but there was clearly a call that was made after.
This exchange may be one of the most revealing moments so far. The defense acknowledges there isn't a direct statement telling the witness, "Don't come to court," but the judge immediately points out something experienced. Judges know well coercion isn't always explicit. Sometimes it's implied through tone, history, repeated threats, or the overall pattern of communication. That means the court isn't just listening for specific words, it's evaluating the bigger picture. Do you think indirect pressure should carry the same legal weight as an outright threat? Or should the law require unmistakable proof before making that leap?
Discussion about receiving a book, and there, in the course of these conversations, at least on 3 occasions, Ms. Caldwell indicates that she called to the Washtenaw County Sheriff's Department. One of those times, she indicates that she spoke to who she said was Miss Justice, but I believe that's probably Sergeant Justice. And so there were multiple occasions where she could have reported some concerns to law enforcement.
Okay, but I'm not even worried about whether or not she reported it. What I'm worried about is, or what the court's in for is during the course of these phone conversations, is there conversations that would lead to at least some inference that she shouldn't appear, or some type of coercion, something in these phone calls?
My interpretation
Okay.
with regard to the particular statement, and in speaking with my, that there is a breakdown, there's concerns and things like that, but not a specific statement, do not come to court. No, there is not.
Well,
Or is there a statement?
But Ms. Gaines, you know as well as I do that you don't often get that don't come to court. Sometimes you get that, but that's not.
The courtroom is about to shift from legal theory to actual evidence. Up until now, both sides have argued about what the law requires. But now, the prosecution begins explaining the content of the recorded jail calls themselves. This is often where judges make their most important credibility assessments, not just by reading transcripts, but by considering the words, timing, and emotional context. Pay close attention, because these recordings could become the deciding factor in whether the complainant's statements are allowed into evidence.
But I'm, in terms of answering the specific statements that are alleged to have been preventing her from coming to court, in terms of the whole context of the conversation, there are not. Sometimes in relationships, people say things to each other because they are in an intimate relationship that are expressive of their own distress and their own frustration and their own worry and concern, which are simply expressions to the person that they're, who they find to be their supportive person.
Response.
When I listen to the majority of the most relevant phone calls, it's clear the first couple of phone calls come in right after he's arrested. And I think that that's important. And I think it's instructive. And so that those phone calls essentially tell the victim, court can't stop me, the police can't stop me, I'm still going to be in your life. And to that point, throughout the first part of the phone calls, there's a lot of I love you, there's a lot of future planning. They even figure out, they're even talking about, well, I think that they're undergoing an eviction process, if I understand it correctly. And they're worried.
This is the moment the prosecution has been building toward. They argue that the phone calls aren't just emotional conversations. They describe a pattern that moves from affection and future planning to disturbing threats and intimidation. Notice how the prosecutor emphasizes the sequence of events rather than isolated comments. That's an important strategy because courts often evaluate whether repeated conduct demonstrates intent. The defense will likely argue these remarks are being taken out of context, but the prosecution wants the judge to see a deliberate progression of control.
How they're going to move forward. And then you see it in paragraph 4 in our motion. He says, figure out which direction we're going, start making an expletive plan. I can beat you up either way. I'm going to beat you up. I'm going to rape you. The victim warns the defendant, don't say anything over the recorded call. The defendant replies, I don't give a, if the police find out I'm talking to you, then I'm really expletive. That statement is instructive. We already have him reintroducing himself back into this woman's life on the heels of the incident that occurred on August 5th, right? By August 9th, he's already making these statements. Look what I'm capable of doing, and you know it. By August 15th, he kind of reiterates some of those points. We see that in paragraph 5. One of the calls that's not listed in this report, but was made mention to, that about him telling her to come to court. the court would like, it's about 30 seconds, I can play that part where he tells her to come to court. Because what he says, coming to court, but it's the tone in with which he says it that I think is more instructive. I've got to pull up right here what would like to listen to.
Sure. Why not?
Listen carefully to what happens here. The prosecution isn't relying solely on the words "come to court." Instead, they're asking the judge to interpret how those words were delivered. Tone, surrounding threats, and the overall relationship between the parties can all become relevant when deciding whether a statement is coercive. That's why courtroom hearings like this often extend far beyond a written transcript. A sentence that seems harmless on paper can sound completely different when heard in context. Do you think tone should carry this much legal weight?
Then you're going to go like we're doing the video.
Did she change the input? Hopefully I have this. Explain.
You make money and you want to go fucking blow money for not making money with the person who would be there to the fucking end. Okay? Don't grab fucking money, show up in my court today. Show the fuck up, bitch. You getting hurt, show the fuck up. Show up or I'm never talking to you.
Never talked to you. I literally meant I wanted her to show up. I either pursue this or I
You may not want to keep saying stuff.
So, to me, obviously,
I let you finish.
I'm just letting. I'm sorry.
It's okay. Go ahead.
thank you. So to me, that last part, it's almost, you hear the tone, and to me, I like to think that I'm somewhat reasonable. The court may disagree with that.
Now the prosecution ties everything together. Their position is that the alleged threats, repeated contact, and overall pattern of behavior demonstrate an intentional effort to influence the complainant's participation in court. They even argue that the complainant previously interacted with law enforcement despite having an outstanding warrant, suggesting the warrant alone doesn't explain her later absence. Whether the judge ultimately agrees or not, this is a carefully structured legal theory aimed at satisfying every element required under the law.
And that statement, go ahead, bring it forth. When we look at the coercive control that's employed from the very beginning to the very end of that phone call, it seems to me his intention is to try to avoid responsibility in whatever way he knows. And so to that end, I think that these calls are very tailored to ensure they were intended to do the wrongdoing. He admits that it's wrongdoing, and that they did in fact procure that unavailability. And so for that reason, I think that the statements are admissible. Like I said, also, I think that they meet the criteria under 768.27C. The statements that are going to come in were all made to the officers at the time of the offense. They're corroborated by the officer's observations. So I think there's a number of ways that come in. The last point, that warrant was in January of 2023. This happens in August 5th. She had police contact on August 5th while still having that warrant out. It kind of undercuts the idea that she's afraid of coming in when she already had the contact with the police. So
This may be one of the smartest procedural moves we've seen so far. Instead of issuing an immediate ruling, the judge recognizes that the defense claims there are additional recorded calls that could provide important context. Rather than risk making a decision based on an incomplete record, the court orders more time for review and requests a written response. That's a reminder that fairness in the legal system isn't just about reaching the right outcome, it's also about making sure every side has a meaningful opportunity to present its evidence. Would you rather see a judge decide quickly or take extra time to ensure nothing important is overlooked?
Yes, perhaps I misunderstood Mr. Emmons, so I do want to say that my client is not admitting to wrongdoing in terms of anything that would be coercive or in any way of that matter. Simply violating the bond conditions is not enough for the wrongdoing. The wrongdoing, there has to be some showing that the wrongdoing itself is what is the cause, and that there was a specific intent to cause her not to be in court. All of the things that Mr. Emmons has been mentioning, are from August. However, a month later, or a little more than a month later, September 19th, is when we were scheduled for the preliminary examination, and she did not appear. There are hundreds of phone calls I would bet. However, I can't say for sure because they aren't labeled by date or any kind of order so that I can be certain, and they're mixed in with calls that are between some Spanish-speaking person. So in terms of my ability, at least 2 or 3 Spanish-speaking persons. So I cannot, yes, John.
So, I guess, Ms. Gaines, what are you indicating? That you haven't had the ability to listen to all of them, which may frame a different context to what I've already heard?
Your Honor, that is what I believe, even from the ones that I have listened to, because I have listened to more than 2 calls. I've listened to, I will not count the Spanish ones, but I've listened to.
But Ms. Gaines,
all of those, but my point is, in terms of the context of the calls in their entirety, they are not, as he states, there's the pressure of the eviction. There's what are they going to do with the cats? There's a whole lot of things that are being discussed, including the court dates.
Ms. Gaines, are you indicating to me that there may be calls after these calls that are referred to that lend a different context where he may have, but you don't know because you haven't been able to listen to them all? Is that what I'm hearing?
You're hearing 2 things, that I have not listened to all of them, and there are calls that, at least one that I am certain is after these 2 calls, because somebody says it's the 20th.
Okay, but Ms. Gaines, here's the problem. Because I don't have a written response from the defense, there are all of these phone calls. Based upon what I see now, it's clear to me that there is some wrongdoing. But you're trying to tell me that if you were to listen to these calls, that the court might, that there is at least the possibility that if there are these other calls afterwards, the court might come to a different conclusion. That's what I'm hearing from you. Is that right?
That is correct.
Okay. So if that's the case, I need a written response from the defense so that the people know which calls you're referring to. And I will adjourn this out 2 weeks and give you an opportunity to listen to all.
This is a perfect example of why defendants are generally advised to let their attorneys do the talking in court. The moment the defendant begins volunteering additional information, the judge quickly steps in. Even statements made with good intentions can unintentionally complicate a legal strategy or introduce issues the defense wasn't planning to address. Notice how the judge isn't being dismissive. He's trying to protect the integrity of the proceedings and ensure the defendant doesn't accidentally undermine his own case.
And with a letter that he received from her that is postmarked October 2nd of this year.
This is a week after I was.
Okay, see, so I can frame my own thing. You know, you gotta let your attorney do her job. She's very good at what she does, and you're not helping yourself. But if you want to keep talking, keep talking.
I am going to show it to the prosecutor. And in this card, there's a photograph, and there's also a statement of course, I want you to call. I hate not hearing from you. So I can do the written response if Your Honor needs some more information.
Well, I don't need any more information. I told you what I'd rule right now. You're indicating to me that there are other calls that may lead this court to form a different context to what was said. And so, why does he keep talking to me? Is he done? And so all I'm trying to do is to give you the opportunity to show that to the court.
If I could have one moment just to make sure that my client understands what's happening.
Here's where the hearing takes another interesting turn. The defendant appears eager to move forward immediately, but the judge makes sure he understands the consequences of that decision. The defense believes additional investigation could potentially strengthen its position, and the court wants to ensure the defendant isn't giving up that opportunity without fully appreciating the risks. Judges have a responsibility to make sure important procedural decisions are made knowingly, especially when they could significantly affect the outcome of the case.
That everybody in the world doesn't hear it. I can.
No. I will ask. Your Honor, this matter has been adjourned previously, twice, and Mr. Caldwell does not want another adjournment.
Well, then I'm ready to rule on the motion and proceed. I don't have a problem. That does not get to that issue.
I understand now. Mr. Caldwell is requesting that I ask if you would speak.
If I would what?
If you would look at me.
But what does that, what would that tell me regarding this motion? Nothing.
I understand. If you're ruling.
This exchange says a lot about the judge's approach. Rather than rushing the defendant into a decision, the court repeatedly offers him the chance to privately consult with his attorney. That's a fundamental part of due process. The judge is making a clear record that the defendant understands his options before choosing whether to delay the hearing or proceed immediately. It may not be the most dramatic moment in the courtroom, but it's one of the most important safeguards in the justice system. What would you do in this situation? Move forward today, or take extra time to strengthen your defense?
Well, understands. I'm prepared to rule on the motion with what's in front of me at this point in time. So that I'm real clear, I would be ruling that the people can proceed by forfeiture, meaning you're wrongdoing. Your counsel, in her way, has been asking the court that there are numerous calls that, if she listened to them, may or may not lead the court to in another direction, not to allow this to proceed by forfeiture by wrongdoing. If she turns out to be correct, you need to understand that if I find that there's no forfeiture by wrongdoing and the alleged victim not appearing, the matter would be dismissed, which is what she is thinking about trying to get to. Whether she can get there or not, who knows? But if you don't want me to give the time for counsel to do that investigation for you, I won't, and we will proceed today. So if that's your choice, I just want you to clearly understand so that if it turns out that you're bound over to stand trial, you're not looking at anybody else in terms of that decision. You clearly would understand why this is happening. You understand that, Mr. Caldwell? That was a question.
I mean, I do. It's just, I mean, okay, based upon what the court has said, because I'm just trying to be fair, do you want an opportunity to speak a couple minutes with your attorney in private so that you can figure out what you want to do?
As this hearing comes to a close, one thing is clear. Today's arguments weren't about determining guilt or innocence. They were about whether the prosecution can legally present critical evidence despite the complainant's absence. The prosecution argued that the recorded jail calls reveal a pattern of intimidation and coercive conduct that led to the witness becoming unavailable. The defense countered that the complainant's outstanding bench warrant and the broader context of the conversations create reasonable doubt about that conclusion. Rather than rushing to judgment, the court chose to prioritize fairness by allowing additional time for the defense to review all of the recorded calls and submit a written response before making a final decision on the motion. That careful approach reflects how procedural rulings can shape the direction of an entire criminal case long before a jury ever hears the evidence.